First question, Steve, it dropped in during your segment. It is open to everyone as well. And it was just asking, what is perhaps the major benefit that you've seen when it comes to having mediation perhaps before arbitration or indeed litigation?
It's the major benefit comes down to one word, and it's cost. Mediation could typically be resolved in perhaps a day, maybe a few days, but whatever it's going to take, it's going to be a lot less expensive than undertaking either discovery or the process, even of arbitration, which won't have all the the bells and whistles of discovery and litigation. It's still going to be expensive and quicker. And, really mediation could result in a settlement agreement where parties get to fashion their own remedy in a sense. So it kind of brings things to a close a lot faster so you can get on with your business and not worry about legal disputes.
Let me just add that in my experience, the pre-suit or pre-arbitration mediation doesn't often result in a settlement of the claim, but it could set up the framework for further discussions down the road. The biggest problem we run into with pre-suit or pre-arbitration mediation is that there hasn't been discovery and the parties have been, in their respective camps prior to mediation, and maybe they're hearing about some of the potential weaknesses in their case for the first time during mediation, and they need to take a step back to evaluate them in order to have maybe a more effective mediation at some future date. And sometimes what the parties realize is that they're so far apart in how they perceive the claim that they need to litigate or arbitrate for a while before they revisit the mediation process again. But it can be very helpful, as Steve suggests, in either getting the claim resolved before you end up in litigation or arbitration, or maybe even setting the stage for a settlement later. Or, a third option is also just to get some pre-discovery to find out a little bit more about what the other side's perspective is on the dispute.
Thank you so much for that. Gary, a quick follow-up question, just asking for some best practice here. Just asking, how would you perhaps recommend one were to perform the owner, contractor, and subcontractor reviews in the most effective and efficient manner? Just looking for a little bit of best practice there, Gary.
Boy, that is a tough question. I will tell you that, again, the higher the stakes, the more thorough the review. And I've always found that the most effective processes are when both the client and the lawyer engage, and that you make sure, again, you have somebody on the contractor or owner side who is, has the right experience to review the contract to understand where the potential pitfalls are or the potential minefields are. And the same is true. You hire a construction lawyer to help you with a construction contract, not somebody who has no experience there. And if both parties can do a review and compare notes, sometimes that can be a very effective way of figuring out where the problem issues are potentially in the contract.
Thank you so much for that. And our final question, Karlee, this is for you. It dropped in during your segment. Again, just asking for a little bit of best practice. You talked about the importance of mitigating risk through, robust record keeping. Are there any pitfalls that you've found in, your experience when it comes to holes in record keeping, any sort of spots that people should be mindful of, and really any best practices to maintain those moving forward? Is there a case of keeping a checklist or what have you there when it comes to keeping and maintaining records?
So generally speaking, you want to incentivize the person who's going to be performing that particular form of record keeping. Let's say it's the project manager who writes the daily reports, or the superintendent who photographs the progress of construction on a daily basis. You're going to want to incentivize them to remain on the project for the duration of the project through items such as bonus provisions or early completion incentives, and ensure that they're very well trained, not just on the technical elements of what should be in the report, but how to save those reports to a cloud, the project-specific cloud, and ensure that those files are maintained in perpetuity, so that if the unfortunate event of a dispute does arise, you have a bevy of admissible business records to cull from to substantiate your claim or your defense.